Today we are going to be joined by Christopher Stanley. Christopher is the litigation consultant with KRW Law. Listeners will remember that we had Kevin Winters on not so long ago talking about the work of the firm. Christopher has a very kind of specific role within the firm, and I think it's very interesting to find out what he does. He shares his work, his day-to-day work, although it encompasses so much. He's got quite an extensive career working within human rights and public law, and he'll take us through that. But just by way of introduction, Christopher is a graduate of law from Warwick University, and he actually worked in academic. He was an academic within third level institutions before he actually went on to become a caseworker in the Oakington Immigration Reception Centre, employed by Refugee Legal Centre. Now that's a very, very interesting piece of work. He was there from 2000 to 2010. And he later moved on then to join the British Irish Rights Watch, which is an NGO, as a legal officer. He had qualified as a barrister in London previous to this, and he worked on producing reports around the Omagh bombing 1998 and the Ballymurphy massacre in 1971. So he has done extensive work there around legacy issues relating to Northern Ireland, and has worked extensively with other NGOs on that piece, including Amnesty International, Justice, Liberty and CAJ, who we've spoken about before on the podcast. So very interesting work there before he joins KRW as a litigation consultant, where he represents the interests of the practice in London, which is very interesting. He leads on responses to policy consultations, specifically on the legacy of the conflict in Northern Ireland and most recently the Legacy Bill. He leads and collaborates on England-specific conflict cases, which includes Birmingham and Guildford pub bombings in 1974. He also contributes to the representation of victims and survivors of systemic abuse across the island of Ireland, and engages with international human rights organisations, including UNCAT, on these issues. He has led on contributing KRW submissions to the recent Truth Recovery Design Panel, and he will represent the firm at meetings with governmental departments and politicians in Westminster and in Brussels. So he has also recently been nominated as the Public Law Lawyer of the Year and one Times Lawyer of the Week. He also obviously works with the firm KRW, which was the Legal Aid Firm of the Year winner in 2020. So we hope you enjoy this recording, and we will also publish links to some of Christopher's work. He has written quite extensively on a number of legal issues, and I think it makes for very, very interesting reading. So hopefully you enjoy. Thank you. Hi everybody, welcome to this recording of Activist Lawyer, and I'm very grateful to Christopher Stanley for joining me today via Zoom. Hi Christopher.
Well, good morning, good afternoon, hi.
And where are you joining us from? Which part of London?
I'm in southeast London in Crystal Palace.
Oh, very, very
good. And it's very sunny.
Very sunny. Well, it's sunny today in, I'm looking out the window now, kind of a typical Newry day. There's a little bit of sun peeping through there. But I know I'm catching you at a busy time. We've gone through your bio there, and I mean, it's extensive. And we're going to focus in on some of your the current work that you're engaged in at the minute, which is very, very important. I'm really interested to find out more about that. And your thoughts on activism and the law in general, because I think there's no better person, given your experience, to comment on that. But firstly, I'm going to go back in time.
That's very kind of you to say so. I'm not sure that's true, but it's like...
Well, I've read quite a lot of your the articles that you've written as well, and I mean, to say that you've gone into detail in wide-ranging issues such as immigration and all of the legacy work as well that we'll get into now. It'll be really interesting to hear your commentary on that on a general level, and then specifically. But just going back in time a little bit, you might take us back and our listeners back to how you started out in law. I think it was back in, wasn't it Warwick University that you went to?
Yeah, I went to Warwick between 1981 84. I come from a very ordinary Middle England background. Went to a comprehensive, which had been a secondary modern, actually not even a grammar, but I had some very good teachers. I had an ordinary family, and I was the second person in my family to go to university. I was certainly the first person to do law.
Okay.
And both my parents and my teachers said I could do what I wanted when I had a proper, solid degree. So therefore, I was cajoled into doing law as opposed to English or history or drama or anything like that. And I went to Warwick, A, because it was quite near, B, because it was quite near to the Royal Shakespeare Company at Stratford, which I spent a lot of time going to. And C, by default, because I found out very quickly that Warwick was a relatively radical campus university, even in the late 70s, early 80s, and that the law degree there was one of a law in context approach.
Okay.
Certainly not a rules-based or normative approach to teaching law. So instead of property law, we did housing, and instead of revenue law, we did welfare benefits.
Yeah.
And obviously there was no such thing as human rights in the early 80s. But we did have civil liberties. And I do remember, I think it might have been Bernadette McAllister was invited to speak to us in a constitutional law lecture, and she brought a rubber bullet, which came as a bit of a shock to many listening and seeing a rubber bullet for the first time. So law, what it was about, social justice, law as power, legal realism, and something we might touch upon a bit later, which was my mentor, William Twining, spoke and wrote about the conjunction between Pericles, the noble lawgiver, and the plumber, who is basically getting law jobs done, which is a balance which I've held very close onto. And in terms of politics, I mean, yes, it was the time of the rise of Thatcherism.
Yeah, I was going to say it was a very kind of heightened time in terms of the political environment. And obviously you mentioned Bernadette McAllister there as well. You would have been very familiar, obviously, while we were living through what was happening in the north at the time, as well as you mentioned, your Thatcherism. So did it feel like it made kind of sense to you in terms of, you know, the context within which you were studying in Warwick compared to maybe other universities that had a more kind of...
Oh, God, yeah. Absolutely. The miners' strike was incredibly important within the law school. And, you know, we were offering advice to miners and in actions against peace and so forth. Thatcher came to campus and loudly demonstrated against. But, you know, I'd grown up in the 70s and had gone through the 3-day week, power cuts, the power strikers striking then, collapse of the post-war political settlement and the rise of the right, which became Thatcherism, the rise of the National Front and BNP and racism. But also, I'd throw in something which is important to me and may amuse other people, the importance of punk. I'm a child of the punk generation.
Right.
Both not just the music, but the aesthetic, the cultural, and the political nature of punk. Which doesn't make me a punk lawyer, but it makes me understand the importance of a countercultural movement and as being a sort of countercultural lawyer, perhaps. Why I then went to London to the bar, I've no idea. I mean,
so that's what I'm wondering.
I wanted to go to the bar. I wanted to go to London. Partly because of punk, I think. Partly because of theatre.
So were you a punk?
The bar. Yeah, I was a minor punk.
Right.
And I went to the bar because everybody else was going to business stuff. And I presume I have that sort of nature that says I'm not going to do what everybody else is doing, which is slightly arrogant. And I didn't survive the bar. I got a grant from Staffordshire County Council. I think the only person ever in Staffordshire to get a grant to go to the bar. Which I did the bar course, but it was no disrespect. It was an Oxbridge-dominated course by rote,
right?
Which I just didn't have the intellectual capacity to engage with or want to, really. I enjoyed London, probably far too much, and I was called to the bar. I passed the exam, but after that I basically ran out of money. And in the 80s, you really couldn't survive pupillage, getting tenancy without, from my point of view, private income, which I didn't have. And despite the support of my inn, I just couldn't hang it. And it might have been lack of courage as well. Yeah. It was a completely alien atmosphere to me, the bar.
I'd say
and therefore I was called...
Sorry.
Go on.
No, go on.
Therefore, I scuffled, in the absence of money, I scuffled back to academia where at least I was secure, job security and an income for the time being, and probably stayed there far too long. But we can talk about that in a minute.
And that was this was my next question. You did go back to academia and you published as well. You became a senior research fellow in law and social theory in 1996, which again would have been at a very, very interesting time. What made you then transition, I suppose, from the academic world? And we can talk a little bit in detail about that and how you find that, because a lot of the guests we've had on the Activist Lawyer podcast have remained in that field, or they've gone between the two. So it seems to be quite common, and it's a question that we get asked a lot about from listeners as well. You know, should I stay in academia? That's where I'm interested in theory. But you know, what was it like to transition? I suppose it was the first kind of work that you got into on a practical level was immigration, as I understand it.
Yep.
But how did you make that jump, and why, perhaps?
Well, firstly, it's my personal nature. I'm not afraid to leap. I think, and you know, I'd had the security. I'd been part of the critical legal studies movement, the Critical Legal Theory Alliance. I published my monograph, and I was beginning to. I was never a very good teacher, or a very enthusiastic teacher, and I was literally in an ivory tower on the sort of 20th floor of a tower block in central London, teaching law and being a research fellow. But I was increasingly thinking and writing about justice and community, and particularly about those who are excluded from justice and denied a community. But I was far behind the skirting board of reality and consumed by theory, and therefore a collision of professional and personal circumstances persuaded me to change direction. I was professionally qualified. I'd never practiced. I was now living in Suffolk for various reasons. And Oakington, the immigration reception centre, although it's never a reception centre, was advertising for caseworkers. So I took the leap into practice in a very sharp way, I suppose. And Oakington, not many people know what Oakington was or represented, but it was one of the first fast-track detention regimes in a secure environment. So not only were those claiming asylum in a secure environment behind gates, subject to a prison-like carceral regime, but those who worked in there as well.
Really? So you were actually in-house there, providing services to clients that were detained there?
Yes.
Wow.
Yep. There were two teams. There were two NGOs on site, the Refugee Legal Centre and the Immigration Advisory Service. I know that you spoke to Colin Yeo, who worked on the same time as I did at Oakington, and we provided on-site legal representation, which is absolutely novel to get that sort of funding from the government. But it somehow justified the government's position to say, well, you know, it's a hostile regime, but we're providing non-partisan legal advice through government money to independent lawyers to give these people representation, which they did.
Yeah.
That was highly controversial within the sector that they should have engaged with it in the first place. But then the hundreds of thousands of people going through Oakington would never have had independent legal representation because it was a fast-track 7-day-a-week process, working on a shift system from about 8 in the morning till 10 at night.
Gosh.
And apart from Christmas Day, it was open and processing and removing people within 6 to 7 working days. So on day one, the detainee, the asylum seeker, would meet his or her legal representative, be briefed through the process. On day 2, they'd have their substantive asylum interview. On day 4, you had 2 days then to put in your representation, and on day 5 you got refused, and that was it. You got refused. I mean, that's the nature of it. And then on day 7 you got removed.
Wow. Usually
into further long-term detention or into temporary admission, or you could be removed entirely. And at first, the nationality list was relatively small. People from China, Pakistan, and so on and so forth. And then increasingly the list got longer and longer to include Iraqi Kurds, Iranian homosexual people, Zimbabwean farmers, and after 8 years or so, most representative asylum seeker countries were being processed through Oakington and other centres which were being established. So you were literally immersed.
Yeah, gosh.
With the Home Office, the Refugee Council, Group 4 who ran the site. All together, you ate together, you got escorted around, and it was living in a detained environment, which then for a further 2 years I worked exclusively in prisons with foreign nationals in prisons throughout eastern England. And these are prisoners on the wing awaiting deportation, having served sentence, or sentences even for passport offences, etc. But with proper sentence prisoners, so to say, ordinary decent criminals, as they say in the north. Some people completely out of it. It means sort of I've just came on a false passport. I didn't even know it was a false passport, and now I'm sharing a cell with a multiple murderer. But
my goodness,
that sort of situation, and that led directly to doing tribunal work for substantive appeals, bail applications, deportation applications, and get to cutting your teeth, both in terms of the practicalities of lawyering in a detained environment, but also the practicalities of advocacy in the factory system of the immigration tribunal, because that's what the immigration tribunal is like. It is a factory.
Yeah, a factory system. So that was between 2000. So you did that for approximately 10 years in total.
Yeah.
Fully immersed in that work. And would you say that working in immigration and asylum, is a good start to getting your kind of, as you say, cutting your teeth in terms of the practical experience? There's advocacy. You're looking at so many different issues there. You've mentioned unlawful detentions, advising people who are in prison. So you've got the legal, the criminal element coming into that as well. You did 10 years of that, and within that, I know you were advising on other types of immigration matters like work permits and family reunion applications as well, and EU related law. Did that give you a good grounding, do you think, in terms of getting that practical experience?
Well, it taught me to be a plumber. And because I volunteered for the CAB in East Anglia, I became a specialist immigration advisor in addition to doing detention work, asylum work. That was very useful for me to do the CAB work. I'm not even sure now that CABs exist in that form, but certainly cutting your teeth at CAB with somebody just walking in with a carrier bag full of documents saying, that's it, that's my life, sort it out. Yeah. Particularly for immigration stuff, that was incredibly useful. Working in a detained environment, it's hard. You don't get trained for it. You don't get support not that you need support. It's a very specific environment for anybody who works in detained environments, be it psychiatric hospitals, secure units, prisons, etc. But doing that, the immigration work and the tribunal work, it's cutting your teeth. And I think it's a very good grounding with all sorts of practice. And if it doesn't make you an activist lawyer, I don't know what does, really.
I think you're right there. And also you're working with so many...
But after 10 years, you do get not compassion fatigue, but you do find that the batting against the Home Office and constantly, 99% loss can be debilitating. And you have to work your way through it or get out.
Yeah, we've myself and my colleagues have witnessed that here as well. In terms of people working on asylum and immigration matters, it just becomes so disheartening and soul destroying. Yep. And to be part of that factory kind of system, it still continues to this day. But and it was Oakington that we tested whether it was legal in the first place. It was Oakington where I learned the basics of judicial review in cases like I wasn't directly involved in Saudi. But Saudi went from, was the challenge to the Oakington regime, went all the way to Strasbourg. It was our case at the RLC. We took it. Other cases have since been taken to Harmersworth and so forth. But I think, it was Colin who said, 20 years on, it hasn't changed. No, I know. We're still looking at disused airfields and old prison ships. Old barges.
Yeah.
So taking a quick break here to say that I hope you're enjoying this episode of Activist Lawyer. Again, we'd be grateful if you could like, share and review the podcast, and please check out our website at www.activistlawyer.com, where you will find some Activist Lawyer branded merchandise and some blog articles. Please tune in on Apple, Spotify or the platform of your choice for more great episodes coming soon. I suppose you're working with vulnerable people, vulnerable groups, children as well, unaccompanied minors and families, etc.
Yep.
And then you moved on to a really interesting position as legal officer with the NGO British Irish Rights Watch, where you primarily worked on developing a litigation strategy in relation to third-party interventions and public inquiries. Also, when you were there, was this your first kind of work relating to Northern Ireland issues issues is the wrong word, but inquiries like the Omagh bombing and the Ballymurphy massacre, which we of course covered on previous episodes here. How did that come about? And that's quite a big shift, but I know you already had the legal stance there in the grounding with your previous work, but what took you to the British Irish Rights Watch?
Well, pragmatically, the RLC, the Refugee Legal Centre and the Immigration Advisory lost their public contracts to offer on-site legal representation to asylum seekers. So many of us were facing unemployment. Yeah. The sector for immigration law was getting harder and harder and smaller. And perhaps I jumped ship, I don't know. But I was getting increased, as I said, the constant losing. You go to a bail judge 8 times for bail and they still don't remove the person, can be grinding, not just for the person who's still stuck in detention, but for the lawyer trying to get them out. And there was that aspect of it, that the sector was getting more and more hostile. There was the prospect of unemployment. And also I was increasingly interested in the policy aspect of NGO work. So it's a continuity. There is a continuity. I was still within the NGO sector. Yeah. I was still doing client-based work, both individual clients, victims and relatives of the conflicts in Northern Ireland, and groups, as you mentioned, the Omagh bombing, Ballymurphy, and so forth. Yeah. And there was direct continuity because the first task, the first project I was engaged in at BRW was monitoring the Baha Musa inquiry regarding British military human rights violations in Basra in southern Iraq during the incursion there, and tracing what's now become known as from Belfast to Basra and back again, which PSC were working on as well. So I was back to doing work with Iraqi people who suffered at the hands of the British Army, and increasingly getting involved in, yes, as you said, the inquiry and inquest work, and getting to terms with the conflict in Northern Ireland, but taking a client base, developing a new client base, developing new areas of work, including, as you said, policy, inquiries and inquests, continue to work on judicial review, learning about third-party interventions by NGOs, including third-party interventions in the Iraqi human rights jurisdiction cases such as Al-Skini and Al-Sadoun, but also third-party interventions in very specific Northern Ireland cases, for example, the length of pre-charge detention and Article 5 of the Convention in relation to the detention of Colin Duffy, and also the right to speak Irish in the courts, which was a big issue. And I also led on, this was completely new to me, the Bill of Rights of Northern Ireland, which subsequently got thrown into a very large circular waste paper basket, and the consultative group on the past in relation to the outworkings of legacy laws, which I spent the last, along with many other people, 12, 13 years working on the legacy of the past and all the initiatives which have come about until the legacy bill, which we'll probably talk about in a minute. And also had that continuity of still working with NGOs. Now I was working with CAJ, RFJ, WAVE, PSC, amnesty, but also with NGOs with an asylum-seeking profile such as Redress and Reprieve. And I mean, I did that for 5 years, and it was then a natural transition.
Yeah, I was going to say because, to your current position in KRW.
Well, I think there's a natural transition there because I felt that with the binning of the Bill of Rights for Northern Ireland, which Monica Williams and her team had presented to the Secretary of State as they were asked to under the agreement, the reneging on the Stormont House Agreement in 2014, the undermining of the Good Friday Agreement, meeting Secretaries of State with clients such as Michael Gallagher, such as Geraldine Finucane, and despairing at the attitude of the British government in relation to what I still wrestle with about Northern Ireland. And the commitment of the convention generally in English polity, and the commitment to the Human Rights Act, as we've seen over the last 10 years, which has been wavering. But the NGO sector is civil society, which is crucial in Northern Ireland. I think my role as a lawyer would have been better served as to public and private law litigation in relation to many of these issues, which is why I now am with Kevin and KRW.
Well, we had Kevin on not so long ago, Kevin Winters, of course.
Yep.
He really had a fantastic recording with us and went into detail about his kind of entry into the legal world, and also the very, very difficult and tragic cases that he works on. So you are litigation consultant, and I think you've been there since 2014, am I right, with KRW?
Yep.
But you're based in London. So is that, how does that work in terms of, is that strategic? Do you think that's helpful to the firm as a whole? Do you specifically represent then or work with clients who are based in England or outside of Kevin's kind of, here, I know he represents North and South. And also then, I mean, we'll get into this in more detail, but the type of work that you're doing, and we'll kind of go through a few of the kind of more specific cases. But just in terms of that, you being based in London, how does that work, and is it working?
When I was at BRW, I'd spent probably half my time in the north, and also in places like New York, Washington, Geneva, and Strasbourg and places. And it's certainly true that post-pandemic, I don't think it really matters to a great extent where you are, unless you're needed in court or in Stormont or in the Doyle or wherever. And certainly Kevin and I are in regular communication every day from 5 a.m. till 10 at night sometimes. That's not my choice, Kevin. And as he says, it's like having somebody next door. The fact that I'm in Penge, southeast London, doesn't matter.
Okay.
What it gives the firm, I hope, is a London profile. We have a Birmingham, we have a Dublin profile, we have a London profile. It gives the firm my research capacity. We have very good researchers in the firm, but it gives them another research capacity and a skill set. I tend to lead on information rights, FOIA, and so forth, just out of default because I've done lots of FOIA work. It gives our clients in England, be they our abuse clients or our clients such as the Birmingham Pub Bombing relatives or the Guildford relatives, a contact point.
Sure. It
gives the firm direct access, partly because I've worked hard at it with Westminster and the civil service in Whitehall. It provides the firm with a continuity with the civil service organisations I've worked with before. So there are those reasons why I think that's why London, and also obviously I can go to counsel in chambers here, we brief and instruct, and be a physical presence in chambers,
course,
and go to meetings as opposed to a disembodied looming presence over a Zoom or a Microsoft Teams meeting.
So, I mean, you lead and you kind of collaborate on, I suppose, the England-specific conflict cases, if we can call it that. In terms of your daily work on that, I mean, are you involved in research and collaborating reports? Harken back to your previous experience, and
I do case briefs on themes which people might suggest. So Kevin might say, "Have we thought about this as a litigation strategy? Is there any mileage in this in terms of a JR?" And I'm usually the one who puts together the brief as a general sort of working paper to say, have we got an eligible client? Is this a runner? The pros and cons. I'll also do the briefs to counsel as the background work of this is what we want to achieve, or this is what we think could be done by litigation. So I tend to do the briefs of that sort of nature. Yeah. There's no typical day, as anybody working in a sector will note. So, for example, yesterday, we had the announcement of the process to appoint members to the board of the ICRIR and the Legacy Bill, and the contention of the citizenship nationality requirement for those board members, and the contention that these appointments are being made even before the bill, which had its further reading yesterday before the Lords, is even received royal assent. And it is clear from our point of view that this proposed appointment process, particularly in terms of nationality and citizenship, would rule out those in the North who choose to identify as Irish nationals unless they qualify, unless they have dual citizenship. It offends the Good Friday Agreement. It's unlawful in terms of Section 75 of the Northern Ireland Act, and it's certainly another huge movement away from the spirit and the letter of the Stormont House Agreement 2014. So we put together I put together a PR draft. We put together a letter, which was then sent to Lord Kane directly. And I didn't expect to do that yesterday. So that took me the morning. And it might lead to a JR because somebody who might apply as a victim, for example. And we've seen this in the South with the panel on the panel established under the Burials Act that has to have representatives from those people who've been affected by unlawful burials are being excluded from that panel. And a relative victim in the North who might want to sit on the Information Recovery Board might be excluded for the reason that they choose to simply say, "No, I'm an Irish citizen." Right. So there may be a judicial review of that. But I didn't expect to do that yesterday. But it needed to be done. Yeah. And, we do media because media is a very powerful tool because it's about awareness and understanding. So what might seem relatively, we're asking about the criteria for a job. It's not just about the criteria for the job. It's the fact that it's a criteria for a job which is going to exclude the very people who are going to be affected by this process of the board, never mind the whole dreadful nature of the bill itself.
Yeah. So on that, I mean, you've extensively worked on and contributed to the legacy work. We discussed a lot of it in detail with Kevin previously, and you play a very important role in that. But I'm also interested in your work, which is kind of quite relevant, well, very relevant at the minute here in Northern Ireland, all for probably the wrong reasons. But in terms of your representation and your work with victims and survivors of systemic abuse across Ireland, and in particular, I'm thinking about the mother and baby homes. There's been a few reports recently on that. Yep. What do you do in terms of kind of, I suppose, trying to push that forward? And I mean, are you and your colleagues frustrated, and I suppose the clients that you represent, at the fact that we have no functioning executive here to carry this work forward?
Yeah. In terms of, that's two questions. The representation of those survivors, we will continue to represent and support and advise because that's what we do as professionals. In the absence of any functioning mechanism and the absence of any forthcoming realisation of either a panel or an inquiry, we are perfectly understand. We know there's a power vacuum, there's a vacuum, a lacuna in the centre of government in Northern Ireland, in Stormont, and without, we've seen the extension of civil service powers again this week by the Northern Ireland office. So we've got government by civil servants. And apart from constantly pressurising both the domestic community in the North and Westminster, but also the international community, because our international obligations in relation to the human rights violations which have been inflicted on victims and survivors, we can only continue to advocate. But the thing about activist lawyering, you can only activate when there's something to activate against. At the moment, we've got to avoid.
But
there may be goodwill in the goodwill in the civil service. There may be goodwill because we had Judith Gillespie in place, who was the former ACC PS9. She's now gone. People will take positions and move because nothing's happening and they can't deliver.
So frustrating.
We can't deliver that for our clients unless it's by litigation. And therefore, again, we come back to, in the void of a human rights deficit, be it the legacy of the conflict in North or South, if the state creates a human rights deficit, and there's a point to be litigated around that because there is contravention of a human rights norm, then we will litigate. That sounds litigious. It's not litigious. It's simply addressing the absence of political will. Whether you agree with the political will or not, at the end of the day, it doesn't matter. There has to be political will for these things to happen. And if they're not happening, then if there's a democratic, even if we cannot ask the judiciary to direct a non-existent executive to set up an inquiry or a panel into abuse, and the judiciary would not want to do that. And we know that there are, in relation to the resourcing of the mechanisms of legacy, particularly PONY, for example, the judiciary say this is absolutely dreadful, statutory powers, but the judiciary can't say we direct the executive to give PONY another 20 million. That's not the role of the judiciary. But that's how we have to address it, both North and South.
Absolutely. So frustrating.
Sorry, that sounds like a weak answer, but there's only so much.
No. I mean, that's...
It goes back to being activist lawyer, that activism, you can't you can't... If one step back, the North is being run by the civil service. And by default, the civil service is taking its orders from the Northern Ireland Office. There's a whole question of devolution, devolved powers and so forth. The civil service is perfectly capable of running a panel, running an inquiry, and that's what they will do anyway when the Stormont executive finally signs it off. I mean, you could just cut out the politicians entirely and simply say, but then that would be the accountability point and the transparency point of we're being run by civil servants. Belgium's been run by civil servants for 20 odd years. It doesn't really stop Belgium functioning as a state. Just something very practical about our work on abuse. And yes, we talked about the global lacuna or void in addressing these issues, systemic abuse in the North. I mean, the other party that we don't talk about is not just the state, but it's the Roman Catholic Church and the other churches and institutions that are involved in enabling and failing to protect. They also bear some responsibility for all this, and they get off the hook.
Absolutely.
We've had the issue of money being paid out to victims and survivors compensation, but that money is coming from the taxpayer, which it should be coming from the institutions who can afford to pay the money and have the responsibility to pay that compensation. That's the first point. So therefore, there's a player in these debates about what's happening at Stormont that has to step up and say, actually, we need to be doing something beyond the empty apology, and we can talk about apologies and what they mean, and the rhetoric apology, or hiding behind their Catholics or whatever they hide behind, hoping this will all go away, because it certainly won't. So on a day-to-day, the other thing I was doing yesterday, or the day before, I can't remember, was drafting this is a very specific legal point, drafting a letter before claim regarding Father Malachi Finnegan of Dromore, well known in the public domain as a paedophile, also well known exposed as an RUC informer, using the benefit of his position both as a paedophile and to inform against members of the Republican nationalist community. Drafting a list of claim around the issue of my right to truth. Yep. this is something I'm interested in.
Sorry, you're right to
the right to truth.
Okay.
Right? Do I have a right to truth? Do I have a right to know why the state tortured me? Yeah. This comes out. It's under Article 3 and Article 2 of the Convention, specifically Article 3, and it's a developing jurisprudential norm about, is there a right to truth? Do I have a right to truth as to why the state allowed Father Malachi Finnegan to abuse me when I was in a secure situation of a college or a parish church? Yeah. We get then thrown back as lawyers with either neither confirmed or denied he was an informer, or we can't tell you that because of national security. So in relation to not just the right to truth, we also have, well, what is national security? Well, it's not defined. And in the information rights forum, which I work sometimes, national security, if it means anything, should actually be the national security of the democratic principles which undermine or which uphold our society. And that includes transparency and accountability, which is exactly the opposite to what national security has rolled out as an excuse to deny that Malachi Finnegan was a paid informer and a paedophile, a protected paedophile. So, I want to just expose the clerical institutions who sometimes slip away from the issue of the state and institutional systemic abuse, and they are not going to get away with it. And B, that do victims have a right to truth? Because when the apology is made by the state, the victim could turn around and simply say, "Well, I'm not going to forgive you because I don't know why you allowed what happened to me happened, and you don't understand what you're apologising for. You don't understand the crime you're apologising for." Yeah. So the apology politically enjoys potentially is a very problematic aspect, and part of this is what I'm trying to weave into a fragrant letter before claim, which will probably go nowhere, but it's worth a punt.
It's worth a punt.
Again, going back to, but then is that legal activism? Well, it's legal. It's trying to think creatively using the tools we have as lawyers and the experiences we bring as lawyers to working, because law is not value free. Law is a power structure, and power only operates in relation to other forces or against other forces. And particularly the public law should exist to protect those who are being oppressed by the state and the use of law. That's partly what I see as the role of the legal aid system. That's very much why the legal aid system in England was introduced as part of the post-war settlement as a core principle of the welfare state. Legal aid, to hold the state to account for uncontrollable oppressive power. That's gone. Anybody who works in legal aid is an activist lawyer. By default, they're still working in legal aid. But working in legal aid practice is an activist lawyer, and it's nothing to do with your politics.
It's just a fact.
It's just a fact that that's what you do. Because I could be an environmental lawyer. I could be a discrimination lawyer. I'm not. It's not that I don't choose to be. It's just that
I guess it depends.
Animal welfare.
Yeah, it depends on your area of work and your personal history. What you've lived through. Everybody has had a different definition of activist lawyer and what it means to be one. Just specifically in terms of your work, and I know, your work has been acknowledged widely. Having been Times Lawyer of the Week a couple of years ago, as well as working for a firm who won Legal Aid Firm of the Year back in 2020. So, just in terms of your work and your experience, do you call yourself an activist lawyer, and what does that mean specifically to you, that term?
Well, I don't call myself an activist lawyer, which probably means I have no ground to do this podcast. Given my age, I think, given my background of being, I was educated in the 70s and 80s, and it was about cause lawyering and civil liberties. And to be an activist lawyer was part of a radical move. So I'm in that between generation, between 60s radicalism and 80s Thatcherism. I cause law because that's my experience and that's the practice which I've chosen to develop or have chosen for me. I'm generally sympathetic to the excluded and to the oppressed and to the those outside of structures who may choose to be outside of structures and should be protected for that choice. That just might be my genetic makeup.
I was just going to say, you've referred just earlier on in our when we were discussing, you've called yourself a plumber.
Yeah.
What does that mean in terms of, you know, the work that you do and in the legal context?
To be an activist lawyer, which I know what it is in my head, but I probably can't articulate it, means you have to have certain skills to get the job done and to achieve social justice or right or truth. And the skills are the ones of practical lawyering, of how to draft a compelling letter of claim, how to abide by the rules to have your letter of claim read and not thrown out by the court, for example, by the person you're sending it to. How to draft, how to be concise, how to deploy, how to interpret litigation, how to read case law. These are the skills which basically every lawyer should have. Yeah. And you deploy them on behalf of your clients. And my client base tends to be people who are seeking truth or seeking reparation. Yeah.
And seeking a voice in many cases.
And articulating a voice. You have a specific set of skills which other people, but I have. I don't have other sets of skills which my clients have, and therefore I'm giving them, as I said, to give voices to those who would be silent or silenced. Because many people are vocal but can't articulate their grief, anger, in a way which would be accepted, and that's a contested point, by the system, the state. I heard Owen Patterson, former Secretary of State, in Washington, he was dismissing David Wright, who was Billy Wright's father, and the report into Billy Wright's murder had just been released. And he's old, David Wright's never going to be satisfied. He's a complaining man. Yeah. There was a very dismissive comment in front of me and Geraldine Finucane. And I also sat with another Secretary of State. No, actually, it might have been Patterson again. I've just been burdened by Patterson. With Michael Gallagher in Hillsborough. And Michael and Stanley McComb were explaining why an inquiry was needed. And Owen Patterson simply turned around and said, well, it didn't happen on my watch. So these articulate people, and the system will not listen, and therefore they silence and hope these people will go away. And in terms of the legacy and in terms of abuse, obviously they hope these people go away because they're dying. Yeah. The evidence is literally dying. Therefore, to be an activist lawyer in these fields, we have to be quick.
You have to be.
We have to be precise and clinical. We have to make decisions about legal aid and who is eligible. We have to be careful about crowdfunding. We have to be careful about, adverse costs orders. We have to know how to work with politicians without being seen to be lobbying politicians. Sure. If that means me, and I did this week for a case we have running in Cyprus of a British Army guy who was killed by an American serviceman in Cyprus. If that means me drafting an early day motion for an MP who doesn't know how to draft an early day motion, or drafting a written question for that MP to send to a minister, or for me drafting the terms of reference for a Westminster Hall debate, that's not me being political or lobbying. That's just me using my skills as a lawyer on behalf of my client to get Parliament to look at this issue. And we've done that a lot in Birmingham. That's a skill set. It's plumbing. Writing an early day motion, which is 300 words maximum, is a plumbing skill. But it's an incredibly useful political skill to be able to deploy because not everybody can do it.
No, useful and necessary. And I'm just wondering on a side
note. And banal, but then much of what we do is banal.
Yeah. It is. And I mean, you've gone through there, obviously, the practical skills and a lot, no matter who you represent, you know, they're the skills that you have to acquire as a lawyer. I suppose it's the clients that you're representing there, you know, bring you down a different context and giving a voice to people who you've just mentioned are either have no voice or have been silenced. But I'm wondering as well, you've written extensively as well, and I've read quite a few of your articles. I'm sure there's so many more that I could go through based on, you know, I mean, they've been published in Irish and just kind of quite broadly, I think it's fair to say. Do you see that as a form of activism as well, in the sense that, you know, as a lawyer, you're able to get a message out on a particular matter through your writing skills and you're harking back then, I suppose, to your time as an academic and somebody who, you know, published quite extensively. Is that part of being an activist lawyer, or is that something that you simply enjoy to do? How does that fit into your work?
Well, thank you for reading the stuff, and thank you for saying I have certain writing skills, which is always nice to hear. I started writing extensively during the lockdown. And yes, I had written an awful lot as an academic. And lockdown, I had things I wanted to shout about. Yeah. And apart from opening my window at night and clapping for nurses, writing was a way of shouting for me. I write in a completely personal capacity. I draw upon in some of my writings on the stuff that I do. Yeah. And anything I feel which is transgressing or getting onto territory which is professionally difficult, I will put to my colleagues, by and large, because writing is an enjoyable thing to do for me, and that's probably what I'll do whenever I stop being an activist lawyer. But writing is also, again, shouting and articulating I don't articulate a political view, I articulate about inequity or inequality or injustice, or failure or corruption, or collusion, which I think are important things to place in the public domain for people who want to read them. So yes, if it is read and taken up and even responded to in a hostile fashion, at least it's had some effect.
It's given some food for thought, and you cover quite a few issues, you know, as well. And I guess a lot of your work in general and your writing will depend on the political climate at the time. And I mean, any of the guests that we've had on here who work in public law or human rights are, you know, either frustrated by what's happening politically. How do you is there a balance between your work in terms of the legal aspect and politics? How does that work? What's the interaction between the two?
Well, I'm going to start with the negative, and I think you might have discussed this with Kevin about the risks, the professional and personal risks of activist lawyerism, and how what we as activist lawyers, those listening and those who are thinking of joining us, risk in terms of the attack and the hostility and the and I often think it's literally, you know, a couple of hundred white men sitting on the back benches, on the green benches in the House of Commons, because it is the Tory back bench by and large, and the Daily Mail reading public. I'm not sure how representative it is, but they have the dead hand over the fourth estate, which is the media. And what we do is easy to attack, because we get paid for it by public money sometimes, and therefore we have to be cautious how we present I think I have to be cautious about how I present the work I do. I'm not scared of being attacked, but I wouldn't want to bring the attack upon my colleagues and the firm I work for, the people I work with. Both, you know, we've had trolls and abuse and stuff, and obviously it goes back to the whole legacy of lawyering in Northern Ireland and the threats, you know, which Kevin spoke about and can speak about far better than I can, which don't go away because we're an easy target with, you know, cat legal aid lawyers or tank chasers.
We've heard it all before, and it continues.
You've heard it. Sorry, you've heard it all before, but
well, I know, but it continues. I mean, you're right to comment on it again, and I think your stance there in terms of it's good advice as well, just in terms of being aware of that. And although, as you say, people don't mind, or we don't mind if we work within this sector of being attacked, and it's going to happen, and it seems to happen more frequently now than ever before, particularly from high ranking members of the government, which is absolutely disgraceful. I think your point there is very valid in terms of being careful as to how that can impact perhaps your client or the cohort of clients that are being attacked as well by the government, by vicariously attacking you or us as the legal representatives. I guess it's just to be cautious about that.
Sam, I'll give you an example of the Birmingham Pub Bombing people who are articulate, they can exercise their own voice, and they do, and they get great to work with. And we've worked with them pro bono by and large for 10 years. Yeah, and every day, virtually, I will do something, or one of us will do something, Barry or me, about the Birmingham Pub Bombings, right? Be it the civil action, be it the call for a public inquiry, be it the failure of the West Midlands Police to investigate, be it dodgy former IA blokes in Dublin, whatever. And Brandon Lewis this time, former Secretary of State, did meet the Birmingham Pub Bombings and tried to sell the legacy bill to them. But he'd also written the week before in Conservative Home, which is the voice of the Conservative Party by the fireside, of tank chasing lawyers offering false hope and promise to innocent victims who deserve better, and the government will give them better. And at this meeting in Birmingham, they usually try to silence, not Barry, but they usually try to silence me, because the civil servants were there on Zoom. I was there on Zoom. Barry was on Zoom. The clients were in the room with Brandon Lewis. And I said to Brandon, well, and he said, who are you? So I'm one of those nasty tank chasing lawyers who's offering false hope and expectation the very people you're speaking to.
Yeah. Wow.
And he completely ignored it.
Mm-hmm.
On the grounds that he was writing for his audience, his constituency. He wasn't writing for my clients.
Yeah.
Yeah.
Absolutely.
And I expected him to. I mean, applaud the guy for his bollocks. I'm sorry. Applaud the guy for his nerves. He just let it right over him. He didn't even say, I didn't mean you. Yeah. Which would have been even worse, because that would have denied my whole existence.
Oh, God. I mean, it's, the work that you're dealing with, obviously you're going to get reaction like that. It's not surprising. But I'm wondering just...
But the sad thing is, if it's not Brandon Lewis one day,
it'll be someone else.
It's going to be Dominic Nard the next.
Yeah. And
Keir Starmer says he will repeal the legacy bill. Well, I'm not holding my breath. But that's no disrespect to Keir Starmer. He will. And I know that Keir Starmer knows the Northern Ireland situation because he was the human rights advisor to the policing board.
That's right. Yeah.
And he should be held to account for saying he will repeal the bill. Now he's going to have a huge legislative agenda when he comes into power. I'm not sure where that. If he comes into power, I'm not sure where that will be on the legislative agenda to repeal the bill, because very few bills actually ever get repealed.
Yeah. But you'll put the pressure on.
Obviously, we'll put the pressure on, but then again, that's the very, we are opposed to the legacy bill because we are instructed, and we represent people who are opposed to the legacy bill. Mm-hmm. We think it's a bad piece of legislation. And we're not alone. As you know, we're not alone in that. We're standing shoulder to shoulder with the DUP on this, and in a very strange caucus of opposition.
Unusual, yeah.
Which is the only thing the only good thing to come out of the legacy bill is the strength of cross-community opposition to it from all sectors.
Yeah.
But as we know, again, I go back to that 200 majority in the Green benches in the House of Commons. That is what this bill is for, because it's about not prosecuting old veterans, which, as we know, the statistics don't add up. Yeah. And people, Dennis Hutchins, who died, was going to face trial for the manslaughter of J.P. Cunningham. Yes, because he should have done. Mm-hmm. Not lawyers. It wasn't the lawyers who decided to prosecute Dennis Hutchins. it was the independent law officers who then get attacked. So, Baron McGrory, oh, you're a Catholic, your father did this, you're a Catholic, you're bound to do this, you're not an independent law officer. Well, that's, we're now not just attacking cat legal aid lawyers, we're attacking members of the judiciary.
Yeah. My goodness.
With impunity, right? And with the benefit of parliamentary privilege, which they don't understand. No. So, I do despair, but I continue to plough along with those who I work for in the great firm that is Kevin Winters.
Yeah. And we thank you for your work and for sharing it with us. Just one final question to you for anybody listening who is interested in, I suppose, your career, your journey and how you got to where you are. What specific advice would you have for anybody who wanted to get in, I suppose, maybe thinking about going down the academic route and transitioning, to practice, or indeed getting into the line of work that you're in? What advice would you have specifically for them?
I hate the word journey. My journey. Well, as I said, be prepared for life changes and life's elephant traps, and that life isn't always smooth. It is for some people. Not sure whether it should be sometimes. Don't take anything for granted. Be prepared for the unexpected. Be prepared to take a leap of faith. Mm-hmm. Yes, you may not always be able to go back, but going back isn't necessarily a good thing. I suppose. One of my favourite images is by Yves Klein, who was a French surrealist, who has a man jumping off a wall in Paris, I think it is, and he's throwing himself into the void. It's staged, obviously. Yeah. But he is just literally coming off the wall. Now, I have that attitude, but that's me. And it's not bravery. It may be foolhardy for me to be like that. Yeah. But I'm at the end of my career. I've probably got another 6 or 7 years to go. Whether I stop, I don't know. I mean, it depends who wants to employ me, and hopefully Kevin will continue. Yeah. I'll go on for as long as I need to do, because my wife will say, "What else are you going to do?"
It's a vocation.
It's not even following your heart or whatever. It's there's more than one path.
Yeah.
And I do believe in having a skill set and transferable skills, be it linguistics, be it the plumbing aspects of lawyering, be it you're a good criminal defence lawyer or you're a good civil litigator. You need the skills basis. And as I've seen in my career, I have a transferable skills basis as a researcher, a writer, and still learning to be a practical lawyer, both in terms of public law, judiciary actions, and also in civil litigation, which my mentor is Kevin. Yeah. So I'm still developing my skill set, and the skills of advocacy, which I learned before the tribunal on wet Wednesday afternoons, doing bail applications for people who patently were not going to get bail, but you still do it. Yeah. So you just have to keep running and pushing, and then suddenly occasionally leap off and see what happens.
A leap of faith. Well, Christopher, thank you so much for sharing your work with us, and also your your career and your advice there, which is absolutely fantastic.
Thank you.
Hope to hear from you again, and I'll also publish some of the links to your articles, which I find very interesting, on our blog, and I would really encourage anybody to just read through them who's interested in Christopher's work. Thank you again, and hope to chat to you soon. Thanks everyone for joining me today. If you like the show, please remember to share and leave a review if you have a moment. And you can also check out our website, www.activistlawyer.com, where you will see some blog articles written by our guests and contributors, as well as some fabulous Activist Lawyer merchandise.
This podcast was recorded in Granite Podcast Studio. Interested in starting up your own podcast but don't know how? Granite Podcast Studio can help. Record your podcast in our state-of-the-art studio, which is based in the heart of Newry City. Our studio has cutting-edge and user-friendly technology and can seat up to 4 people. We also provide an editing service for our team, using your guidance and editing notes to provide you with a flawless finished product, leaving your listeners wanting more. For more information on how you can get started, visit www.granitepodcaststudio.com.